Gears now to a case before the Supreme Court challenging affirmative action in colleges. The court agreed today to reconsider race-based affirmative action in college admissions, which has greatly helped boost the admissions chances for traditionally disadvantaged racial minorities. Like many things, this boils down to fairness for a lot of people. Joining me now for more on this, constitutional attorney Andrew Lieb. So, Andrew, explain this to me, what they're asking for, because right now colleges admit that they do use race at least as a part of the application process, do they not?
You know, I think the end that you just said is what the truth is. They use it as a factor plus. That's actually from a Supreme Court case called Bakey, which was reaffirmed in Grutter and then as recently as 2016 heard in Fisher. But let's talk about what it's really about. People feel like there's reverse discrimination going on, meaning I'm not getting in because of my race. Now, what Bakey says, Joe, and I need to be clear about this, is quotas are not allowed. That's what you and I think about when we think about affirmative action. They're not allowed to do quotas. The case before us, though, is saying, hey, can they even consider race as a factor? Right. Or do we have to, instead of doing race-conscious admissions, do race-blind admissions?
Well, how do we even know, though, Andrew? I mean, because if you don't get accepted, you don't get accepted. And let's just say the university says, listen, we have 10 students here who on paper are essentially the same. What does this boil down to? And if race is a factor, you don't ever know that, do you?
So you and I as an individual, if we were applying, wouldn't know.
Right.
But when these cases come about, like Students for Fair Admission, they're suing right now. They're suing both Harvard and UNC. And in those cases, in what's called discovery, we find out a lot of facts. And you can look back to 1978, where this was first addressed, and a judge named Justice Powell went into great detail explaining it. And really what I think the misunderstanding is, and I want to make sure everyone gets this, is we're not trying to rectify a past wrong, which is what we really think about when we say affirmative action. What Justice Powell said is that the whole compelling government interest is having a diverse student body is better for robust interchange of ideas and education. Now, whether the current systems on how they do admissions are doing it right or wrong is a whole nother conversation. But is there a compelling government interest? Clearly there is.
Yeah, well, how does this change if it's overturned, Andrew, from these colleges that now many of whom are not even using SAT scores and are really just using some of these other factors to decide who gets in?
You just said it right, Joe. So it's about which factors are said to start off with. It has to be a soft factor, and that's what we learned in that precedent from Bakey. We learned that we have to have a soft factor, and they said, hey, you don't need to have a lottery. It doesn't need to be race blind. But here's the most interesting thing. Back in 1978, a quote in the Supreme Court cases, they said, hey, you can't have race be a factor forever. I'm paraphrasing. They said, but hopefully in 25 years, and this was 1978, right, hopefully in 25 years, race will no longer be relevant as a factor. So the Supreme Court that allowed race to be a factor also predicted it being overturned. So I need to point out that back in 2016, when it was last upheld using race as a factor, it was a 4-3 court with liberals taking the lead. We're greatly expecting this to overturn race being a factor. Right. But Joe, it's not just in education. We're going to see this in employment as well, because reverse discrimination is the major argument of our times if you watch any program such as yours.
Very interesting. I was going to ask you what you thought was ahead, but we'll find out. We're going to have to wait, though, because as I understand, we're not expecting a decision until the end of next year. But Andrew Lieb, constitutional attorney, great to have you with us tonight. Thanks for explaining this.
Such a pleasure. Thank you.
Thank you for watching. Click the red subscribe button below so you can get more of NewsNation's fact-driven, unbiased coverage.